Good evening, erudite and experienced speaker Kandasami sir, and all the attendees. All the attendees. I, Pannaraj, Vice Chairman of the SIRC FICI, as requested by my Chairman, Mr. Chinnamastan, and the Secretary, Mr. Naresh Chandragelli. He am here to open up the day's discussion on latest development in legal compliances of NPOs with special focus on Fcra. Members, you know that the importance of the NPOs in the recent past has been of tremendous significance because of the draconian, I can say, if I may use it, the penal and other provisions that are there if you miss out to comply with them. So this becomes more important for another additional reason. We are always, if we think of income tax, we think only of taxation of businesses. When it comes to NPOs, will not be so attentive, but this is so serious business now that we should be concentrating very deeply and very conscientiously to do the compliance part of the income tax proceedings. So in this backdrop, the SIRC has always been there to skill you up or to update you by inviting the experts like Kandasami sir, who is an authoritative speaker on the NPOs for nearly 4 to 5 decades, and definitely all of you will be very much enriched by the end of the session, both regarding a special focus on Fcra of NPOs as well as the recent amendments, that is 22 Finance Act, which are effective from 1st of April. So with this background, I very warmly welcome Kandasami sir for this presentation, and also welcome all of you. Yes, sir. I also welcome each one of the participants for this program. I take the privilege of most of you know Mr. Kandasami sir does not require any introduction, but still it is customary and the professional decency that SIRC wishes to introduce him once again. He is FCA, DISA and PhD holder, and Dr. M. Kandasami is a commerce graduate from Laila College, Chennai, with several medals for his academic excellence. He is also a qualified systems auditor from the above institute. He holds a doctorate in the area of governance engagement in the financial management of non-profit organizations. His field of specialization is governance, financial management, and legal compliance aspects of non-profit sector organizations. He is the pioneer in the country in promoting compliance for NPOs, particularly on Fcra matters, for more than 4 decades. He has co-authored the first ever book on Foreign Contribution Regulation Act 1976, titled The Law of Foreign Contribution and Foreign Hospitality, together with the former Assistant Professor of Fcra Division of the Ministry of Home Affairs, New Delhi. He has also written a popular book known as Governance and Financial Management in NPOs. The professional services he has provided are audit and assurance services, advisory support, representation before tax authorities, teaching, training, workshops and conferences, board and advisory roles of governance of NPOs, auditors network. He has facilitated forming an auditors network for NPOs in India in the year 1990 and coordinates it for knowledge sharing and financial management capacity building for NPOs. With this brief introduction, I very warmly welcome once again and over to you, sir. Kandasami, sir.
Yeah, thank you so much, Vice Chairman.
Visible, sir.
Hope my screen is visible.
Yes, sir.
At the very outset, I wish to congratulate CA Panaraj, Vice Chairman. This is the first opportunity for me to meet together with you, and I have always enjoyed your wonderful support and facilitation in the last several years. And I would like to sincerely thank you for your kind words of introduction. I also wish to request you to kindly convey my congratulations to your team members, the chairman and the secretary and treasurer, all of them. Yeah, and again at the very outset, I would like to thank each one of the participants who are participating this webinar. I know that is a critical time for each one of us on many things. March 31st is the financial year ending, and among other people, the chartered accountant, such a critical time because we have so many responsibilities to complete before 31st March 2022. In a time like this, if SIRC has organized this, I do understand it is with a purpose. And I consider this purpose as some important. And the purpose, as I understand and deliberating with certain members, is if we can do one stitch on time, it can save 9 stitches, is the old saying. But given the complexity of laws for NPOs that Vice Chairman spoke about, one stitch will not save 9, it will save 90 stitches later in so many different aspects. And therefore, I wish to focus the short time this evening on the latest developments for the NPOs, and particularly in the legal compliance aspect. And I would like to not to go to all the, but just to the main points, the current developments, and particularly what can we do before 31st March, for example. If there are certain compliance matters that we can complete before 31st March, what are they, how we can do them, and perhaps some others that we will have to be careful or attentive in the next quarter, next 3 months. So that is the kind of perspective I'm giving to this session. And you can see the title as I would like to remove the photo to see the full view of the slide for myself. I hope it is possible. Just a second, please. Okay, yeah. So title, as you can see, is latest developments in the legal compliance aspects of the NPOs with special focus on FCRA. Three objectives, as I can see. One is to refresh the latest developments in the legal compliance aspects of the NPOs. Second is to get to know the current status of the compliance aspects and the issues. And third is discuss the income tax compliance aspects and the current status of the NPOs with reference to the income tax compliance. Though the title is focusing on the FCRA, I'm taking liberty to spend some time on the income tax because the budget 2022, the finance bill 2022 brought out several amendments and several clarifications, and they all have become an act yesterday when the finance bill was passed. Now it's the Finance Act. Therefore, I'm trying to spend some time. It looks like for our session today, the 26th of March, yesterday and again day before, there are very special news from the government. Day before yesterday, there was special news from the government about the extension of the validity of the FCRA registrations. And yesterday, the news about the finance bill getting approval of the Parliament and has become an act by now. So we are talking about two aspects which are very crucial for the NPOs. So when we say latest developments on the legal compliance aspects, today I am thinking of taking these three things. Of course, the incorporation laws, the other laws and rules and regulations, social security regulations, these are all the regulatory framework. But in the regulatory framework, the incorporation law, as we all know, are these: the Societies Act, the Trust Act, the Section 8 company, and any other unincorporated entities, all this. My focus is not on this today, excepting, for example, the deadline for filing with the registrar of societies in different states are March ending. Therefore, the NPOs have to file their returns under the Societies Registration Act. If not filed, actually it is 6 months after the AGM is conducted. And if the AGM is conducted recently in the last 6 months, March 31st will be the last date. In the other laws and regulations, there is income tax, there is FCRA, there is GST, and of course, the Public Trust Act, which was coming as a bill to Tamil Nadu, is not there, and South India, it is not there. Of course, such an act is there, like in Maharashtra and Gujarat. I'm not planning to touch them this evening. Social security laws is another aspect. EPF and ESI, gratuity, all of them, of course, they all are relevant to the extent the payments have to be made on time, even by the NPOs, in order to claim exemption. And looking at the emerging scenario for the compliance aspects of the NPOs in the country today is something like this. In general, NPOs are under high scrutiny. This is not breaking the news. This is just a confirmation between you and me that there is high scrutiny for the NPOs in the country. Let them be trusts, let them be societies, let them be Section 8 companies, let them be unregistered entities, let them be educational bodies or health bodies or social bodies or religious bodies. There is a high level of attention and scrutiny going on in the country. Those who are deeply involved, you are familiar how much is the scrutiny going on. If you take just a single item like the FCRA renewal, such a lot of scrutiny has happened. Almost every trustee connected to an NGO or an NPO who is registered under FCRA, who has applied for the FCRA renewal, have faced this situation. Now, therefore, NPOs are under tremendous stress. Never before in the recent times they have been under stress. Of course, from Finance Act 2020, after the COVID outbreak, the big stress started for the renewal of the 12A and 80G, and that is continuing now. After that, it is the CSR registration, and after that, it is the FCRA renewal. It is going on and on. Several laws and regulations are enacted. Existing laws are strengthened, new amendments are made. You will see them as we go further. Now, in the history of NPOs in the last, let's say, just take about 4 decades or 5 decades that I have been associated, never they have been going through so many challenges. Their challenges are not only from external but also internal, because internally so much of transformation is taking place in several or numerous NPOs. Therefore, both the pressures are going on, internal pressures and the external pressures. The regulatory framework is becoming stringent day after day. Let it be FCRA, let it be income tax, let it be GST. It is becoming more and more stringent day after day. New laws and rules are enacted, and they have serious implications on these NPOs. Therefore, professionals like us, who are a great safeguard or a support to the NPOs, there is a need for our awareness, our caution, and readiness to respond and support the NPOs who are facing these scrutinies, these challenges, and going through so much of stress. It is in this background I am sharing with you first the topic of FCRA. In FCRA, there is such a lot. It is a law that started in the year 1976 and went through tremendous amendments decade after decade. For example, 1985 was major amendments where the registration, prior permission, and reporting, everything came in place. And thereafter, 2005, there was an attempt to bring a new law that did not happen. And 2010, the new law was enacted, repealing the 1976 Act. And thereafter, every year, if not every month, so many changes, amendments, new rules, amendments in the law, amendments in the rule, amendments in the reporting mechanism from physical to electronic, etc. Now, I am planning to focus on three aspects of FCRA this evening. First is renewal of registrations. Second is filing of the returns. And third, other matters in the FCRA. Now, why I am taking these three? Because first two are still major challenges faced by numerous NPOs. Therefore, I'm taking up the first two, and then the last, of course. So many things are happening. Too many things are happening. It is not my idea to, bring up everything. I would, of course, bring up a few things that you may have already heard about, or you may be already trying to support the NPOs. So you may bring up more in the third category, or even in the first and second category for clarification or discussion later on. I am sure I'll be able to spare, or at least I would like to spare quite a bit of time for our interaction. Having talked about three areas, I would like to go to the first area, that is the renewal of registration, which is still going on. As a matter of fact, very few renewals have been granted so far. If you ask me through my live wire contact with the NPO sector throughout the country, and also with the professionals, our own professionals and others, hardly less than 5% of the renewal applications have been disposed of. This is not an accurate statistics, but if you go by, who are how many are granted in a group and in a state, and how many are not granted and pending, it is roughly less than 5% who have been already got the disposal of their applications. Now, in the disposal, there are two types of disposals have happened. One is granting the renewal, and second, the other is denying the renewal. Both have happened. Now, if they are granted the renewal, then there is no issue. They are okay for the next 5 years, unless any action is taken by the Ministry of Home Affairs, Government of India. Now, in the case of renewals also, some mistakes have happened. I will come to that a little later. They did not, I think, take enough care, either the applicant side or sometimes the government side. I say government side because there are some applicants who have not made such a mistake, but it has crept in there while granting the application. I will go to that little later. Now, coming to the denial cases, quite a few have been denied already, denied the renewal, and therefore now next they have to move on to the next step, next process. Now, what happens if their renewal is denied? They cannot anymore receive any contribution. Not only that, they cannot also utilize the balance amount that is available in the FCRA account. Now, when we talk about FCRA account, there are many accounts. Unlike in the past, in the current regime, there are minimum 3 accounts. The mandatory designated account in the SBI New Delhi, the other FCRA account, which is an account to get the money from the designated account transferred to the this account for utilization, and the third account, a utilization account, purely a utilization account. Most NPOs have all the three. First, they cannot help because it is mandatory. Second, they open and they use it for convenience. And third, utilization account also many have, not one. Sometimes a single NPO has got multiple utilization account because they are operating the program in different parts of the state or different parts of the country. Therefore, they cannot manage with a single FCRA account, including a other FCRA account. Therefore, they operate utilization accounts. Now, any money in any of these accounts cannot be utilized once the denial has happened, and also the bank should not receive any remittance. Unfortunately, it is happening that even after the denial, banks have been crediting the foreign contributions, and that is going to cause serious problems for the NPO because it is a violation that receiving foreign contribution after the denial. Therefore, the action required on the part of the NPO is to give a clear instruction in writing to the bank that the status of the FCRA renewal is denied. Therefore, no credit should be made in the FCRA account. Now, many renewals are still pending for whatever different reasons. One reason for which it is pending is they are raising queries. Another reason that it is pending is the inspection, which has become mandatory, compulsory after the FCRA Amendment 2020, September 2020, not last September, previous September. The inquiry or inspection became mandatory for every NPO who is applying for the renewal, and in some NPOs or quite a few NPOs, inspections also have not happened. Therefore, for the sake of the queries and the response to the queries and inspection not happened, several renewals are pending. Now, there are cases where both have happened. Inspection is over, queries have been responded, still the renewal order has not yet happened. Either granting the renewal or denying the renewal has not happened. So the caution here I would like to recommend is the NPO should see to their portal, the FCRA portal. Some are getting emails about the queries, some are not getting emails about the queries, or we do not know where the queries go. Whether some old email that doesn't exist, we do not know. So it is advisable to look at the portal almost every day, especially these days because the renewal process is going on. Quite a few got the renewal, many are waiting. Therefore, it is important to look at the portal if possible every day so that you will know whether renewal order is granted or whether queries are raised and pending for response or any other matter. Now, some good news, not a great news. I say not a great news. I'll tell you the reason, but some good news, surely, because for those who were worried whether what can happen after 31st March, whether salaries they can pay, whether vendors they can pay, whether they can open, whether they can operate the FCRA account, whether they can receive the first quarter remittance based on the budget, etc., were major questions. Those questions are now answered by the day before yesterday's announcement of the Home Ministry that the registrations who have applied for renewal are valid up until 30th June 2022. If you recollect, last year also they did the same. They first announced May will be last date, then they took it to June, then they took it to September, then they took it to December, then they brought it to March. Now they are bringing to 30th June 2022. But I say not a great news because there are several NPOs who have their annual budget coming from foreign contribution. When I say annual budget, some cases it is April to March financial year, Indian financial year, but many cases that is a calendar year, because several other countries follow calendar year as their budget year, and they want the Indian entity to submit the budget for the calendar year, and they have submitted the budget for the calendar year Jan 2022 to December 2022, but FCRA is kind of in limbo. It is hanging, and therefore it is not such a great news for some of these organizations. However, looking at the brighter side, the validity itself for next 3 months is some breather, and therefore many are not aware of it. Though it has come day before yesterday, still many are not aware of it, and therefore it's good for the members to share this information to NPOs. Of course, I must say also on the other side, some NPOs are more aware than us, because every minute they are waiting for it. It is sometimes lifeline for them. Therefore, they are aware even before we come to know about it. But many are not in that kind of a situation. Therefore, it's a good idea to share about the extension of the validity of the FCRA registration up to 30th June 2022. Let me be clear here. This is not applicable for those NPOs whose 5-year term is not yet over. For example, if an NPO has registration and 5th year is ending only December 2022, this has nothing to do with them. If it is ending in December 2023 or so, it has nothing to do. These provisions have nothing to do with them. These provisions are for those who have completed the 5th year and have applied for the FCRA renewal. Now, what about one category of people? Those whose expiry is going to happen in April 2022, next month, or May 2022. Fortunately, they are also covered in this extension. Therefore, if somebody is having FCRA and it is expiring in April 30th 2022, not to worry, they will be extended. They are covered in this extension up to 30th of June 2022. There is one list called seized list. If you go to the FCRA portal, you will find among several lists that they have given, one category is a seized list. There were almost about I think about 8,000 plus organizations in this in the beginning. Fortunately, many were brought out of it. What is the seized list? Seized list is those cases whose FCRA 5th year has expired, but neither they have applied for the FCRA renewal, nor they have complied with the other provisions, such as opening of the bank account in New Delhi and then annual return filing in form number FC4, etc. Therefore, they have all been put under the seized list. Now, what are the implications? The implications are these are not covered in the extension. The extension of the validity of the FCRA now by the public notice of day before yesterday to all the NPOs who have filed their applications for renewal in form number 3C does not apply to this category of NPOs. Meaning, this category of NPOs cannot receive foreign contribution. Unfortunately, they cannot also utilize the foreign contribution. I must say that the act or the rules does not speak clearly about the utilization in this case, because there is no such provision in the act or the rules about seizing the list. But they have brought out this, and in the letter of communication they have informed these kind of NPOs that you are in the seized list. Neither you can receive remittance nor you can utilize the available balance. That is the scenario. And it is good for us to look at this list and see whether any of our known NPOs are there in this list and caution them. And perhaps if they have complied with everything and they have been put in this list, it is unfortunate. They can definitely represent and they can bring themselves out and they will be coming into the extension category. It has happened to a few hundreds of them because wrongly they were put in the list. What do you mean wrongly? I give you a clear example. A case where on 31st of December they applied for the FC3 FCRA renewal, but the payment did not happen. The fee payment 5,000 for the renewal did not happen for the renewal did not happen that night. It happened after 2 days or 3 days. And on the December 31st midnight, past midnight, I think somewhere about 3:30 or so, I think they have scheduled this list, and this list came out in the open public domain, that is in the website. Therefore, these NPOs who have done everything, they have filed their annual return, they have opened their daily account, they have also applied for the 3C, they represented, because they were so upset, they were so shocked that has happened to them. They represented and they were removed from that list for good, and now they are under the extension category, or even some are granted. The renewal is granted subsequently. Moving to the filing of annual returns, I would like to spend a few minutes, short time on this. This is such a simple thing in the past. I remember in the 70s, 76 this law came, 78 I came in touch, 70, 78, yeah, 77, 78 I came in touch. Such a simple thing, anyone receiving anytime can send one simple form, just putting the amount, no account, no opening balance, no closing balance, nothing. From there, it has become so complex today. And today, there are some NPOs who are facing the fine of 25 lakhs, 30 lakhs, 45 lakhs. I am familiar with those even more such fines. And how the fines have taken place, it's so unfortunate. Some of our colleagues and some of the NPOs were struggling such a lot to go through the process of opening the daily account, and after that they finalized the FC4, and they also uploaded, certified the CA certificate that is required for FC4, and they were trying to upload from some. It so happens some were doing it in the last hour, last half an hour, last 15 minutes, and there were a number of cases which uploaded at 11:58 on 31st December, 11:59 on 31st December, 12 midnight 0000 on 31st December, and ended up with 5 lakhs, 15 lakhs, 25 lakhs, 30 lakhs penalty, just because the full uploading did not take place before 12 midnight. I have came across one or two of a few of our colleagues showing that in the website the uploading is already taken place at 11:58. The documents are there, but unfortunately it did not go through fully by 12 midnight. I'm giving concrete cases how this is happening, and of course there are other cases they could not succeed in uploading their FC4 before 31st December. Now I'm talking about not 1920, I'm talking about 2021, the second bullet. Now in the second bullet, still there are quite a few NPOs who have not filed their annual return. Why? For certain reasons. Number one, their daily account is not yet ready. Why their daily account is not yet ready? Some problem or the other. One major problem is some have not been able to get their Darpan number. As you may be already familiar, the Darpan number is to be obtained from Niti Aayog. Niti Aayog has got a separate section where the NPOs are dealt with, and the NPOs are given a Darpan number. Now, some NPOs, many NPOs managed with a lot of struggle, but some NPOs are going on and on with one issue or the other. I mean, if I go further on that, the microscope, one common problem that they are facing is the name as per PAN and name as per author is not matching. Small difference, and therefore Niti Aayog is not able to grant the Darpan number, and therefore they are not able to they are not able to apply to the New Delhi Bank for opening the account, and therefore they are not able to get the account open. Therefore they are not able to get the Form 6C approved for the Delhi account, and therefore they are not able to file the FC4 for 2021. Now, I have also put in the first bullet 1920. You may wonder, my God, is it 1920 is still not filed by NPOs? Yes, for same reasons that I shared just now for 2021, several NPOs have not been able to file even for 1920, and therefore the returns are pending for them. Now, what is the consequence of non-filing of the returns, or what are the consequences of non-filing of the returns? Several. First one, if the return is not filed on time, firstly, they end up with a huge penalty and fine. And without paying that, there is no way to file the return. You may ask me at this time, is there no waiver, sir? There is waiver for so many things. Unfortunately, there is no provision for any waiver, and nobody has been given a waiver, excepting one or two cases you may have come across in Delhi High Court. There was a decision that one or two NPOs, they argued that for filing their 20 March return, why should they fill up the Delhi account, which became mandatory in September 2020, 6 months before my financial year ended? And I want to file the return for March 2019-20 financial year. You should not compel me to fill the bank account that is applicable only for the next financial year 2021. And the Delhi High Court agreed with them, and they have been able to file the return without any penalty. Now the question is whether it is applicable to all the NPOs. No, it is a specific case. And the other question is it feasible, possible, or asking in another way, is it worth going to the court of law for this purpose? Yes, I have got feedback from several of our colleagues and also NPOs. Some of them it's worth, because the cost involved is a small fraction of their total budget of FCRA, and it is a lifeline for them. But there are others, the cost involved is highly prohibitive. Rather, they will not go for a renewal, rather they won't go for anything, and stop with that. That is also another kind of a perspective that is going on. But of course, it is not merely stopping or not filing or not renewing. There are other consequences of properties. If some NPOs have acquired properties from FCRA, or they have large funds from FCRA, there are other serious consequences of those properties getting vested with the government. And therefore, case to case, one has to see. You cannot take a general view that it is quite right not to renew the FCRA registration. Of course, such a question is also asked for 12-year renewal. After the 12AB, 12 capital A, capital B regime, there is also such a question asked by small NPOs. Is it worth, sir, going for FC 12-year renewal? And what are the consequences? So again, you will have to see case to case. Now, going to one more point, while filing the return, those who are about to file the return with the penalty, one important aspect is the program versus admin. As you may know, those of you dealing with the FCRA and NPOs, September 2020 amendment brought several amendments, and one such is that admin component was decreased from 50-50 to 80-20. Therefore, from September 2020, an NPO cannot spend more than 20% for administrative expenditure. You already know there are definitions. Section 8 speaks about the definition. There is Rule 5 also, which gives a clarity about what are administrative expenditure and what are program expenditure. Of course, if you really go into it, there are still ambiguity there, whether program staff salary is a program expenditure or an admin expenditure. And there are many more questions like that. I may not want to drag you into so many of those unless there are any specific queries, which I'll be happy to answer. Now, the FCRA bank account in the New Delhi main branch continues to be a challenge. Multiple challenges. As I mentioned already, for some people it is the darpans, for some people it is trustees are not clear who are the trustees and who are the signatories. For some people the PAN and the author is not matching. For some people they have resigned, but it is not yet accepted in the government records by the registrar of societies or what, and therefore the bank is insisting, but the NPO is not able to get the signature in the application from those trustees. In some cases, the trustees are outside the country. In some cases, the trustees are no more, but the list of trustees is not yet set right or regularized with the government department. I can go on and on and on. So many issues are faced by these NPOs. And as you know, there are levels of NPOs. There are INGOs who have got best support, best professionals. There are national level NPOs who also have good support. There are grassroots NPOs who are struggling. They don't know what is happening. They don't know what to do. And therefore, if we come to know, or if we have relationship with these kind of NPOs, it is worth attempting to help them. Sometimes it is so simple as that, you match align the name between the PAN and the other, and then matter is solved. Then you can immediately go for that one. You can immediately go for the bank account. You can immediately go for filing the annual return. Then you can immediately go for filing the renewal application. Now, related other issues. Too many issues are going on. I have just put here 3 or 4 of them. First one, renewal and wrong purpose is mentioned there. They need correction. You may recollect a couple of minutes back, I said I will come back to some mistakes in the renewal. So several mistakes have happened. One mistake is a wrong purpose. What is a wrong purpose? To give a simple example, the NPO has applied for social, educational, and economic, whereas in the renewal it has come as social, economic, social, educational, and religious. Now, as you know, if religious is coming there, it has got other implications. First of all, there is no objective in the organization with religious purpose. Secondly, the 12A is not at all about religious. It is about charity, section 215, that is relief of the poor and education. And then this entity also has got 80G. So with this background and with this reality, if they leave this mistake to go on, there can be serious implications. What can be the serious implications? The income tax can question that you have allowed religious purpose. You have even accepted the order of the Ministry of Home Affairs that it is for religious purpose, and therefore we are withdrawing the 80G and we are cancelling the 12A, because you will see very soon that budget 2022 finance act also made it very clear that you cannot use the money for another objective. You have to use it only for the objective for which you are there. Therefore it has serious implications. Just one mistake. There are other mistakes about address of the bank, address of the entity itself. Several mistakes are going on. So some people, when they receive the renewal, they are so happy they don't even read it. They just see renewed. That's all. That is like getting the foreign contribution itself. When they get a foreign contribution, very often they will see remitted, nothing else. The agreement, the contract, the memorandum of agreement will have several clauses about how to use the money, how to account it, how to report it, when to report it. Nothing. They will take up only much later when it is questioned. Similarly, when they get the renewal order, they just see renewed and so happy with it. But their fine reading shows there are mistakes. And I am suggesting not to take up the mistake next day or the third day. Wait for a week or two, so that when let things get settled, then you can start communicating with them to set right the mistake. But if you ask me, should we definitely set it right? No question. No question. It has to be set right. At least you have to write to the ministry that it is wrong and that has to be removed. Otherwise, during the assessment process, particularly faceless assessment process, when you are asked a question that show cause notice SEN for religious purpose, when you are not for religious, we will have no answer. Second one, prohibition to donate an exempt cases. What is prohibition to donate? We are all familiar by now that to find, but the amendment of 2020 Fcra 2020 prohibited one entity to donate to another entity, which became a rude shock to hundreds and thousands of NPOs in the country, because hundreds and thousands of NPOs in the country are not directly receiving foreign contribution from the foreign source. In fact, most of the new smaller NPOs are receiving funds from a bigger NPO who are already located in India, who have received their money, and when they receive it, they give it to the smaller and they call it subsequent remittances, subsequent receipts. But now that is totally prohibited, as you are well aware. Also, you may be also aware that government has power to exempt certain categories from the FCRA. One such exemption happened in January 20, not 21, not 22, 2 years back, January 20. In January 20, the circular came from the government through the section 53 of the FCRA, saying that certain institutions and government organizations who receive government funds and who are subject to C&AG audit, they can be exempted. They are exempted from the FCRA. Now, why am I mentioning this? In the last 2 years, two categories of NPO work suffered a lot, or two important aspects of people. In two aspects, people suffered. One is health. The other is education, as you are well aware. So there is a high level of discussions going on between state government agencies, state government, or certain programs of the state government of different states in India, and the NPOs, whether the state government projects can receive foreign contribution from the NPO or from the foreign source directly, as the case may be. The answer here is, if an institution, for example, a university, take a university, you know that many universities have been cancelled. If you go to the website, you will see many universities all cancelled of their FCRA. Now, if this the circular is applicable to those universities, they are receiving government grants and they are subject to the C&AG audit, then they need not be covered under the FCRA, and anything given to them will be exempt. Therefore, government hospitals have been asking for certain equipments to treat COVID patients. So many equipments were donated by NPOs to government hospitals, to my own personal knowledge, and you must be also knowing. And similarly, so many schools, particularly government schools, for their building, you are aware that how children died because the building fell, in Tamil Nadu and some other places. And also, that how children are suffering because of lack of facility in the school. There is no smart class, there is no smart board, there is no computer, etc. Therefore, there is also high level of discussions going on how the NPOs can support government schools. There again, same issue comes. If these schools can give a confirmation that they are government funded and they are subjected to the C&AG audit, then the NPOs can give monies, or also foreign agencies also can give monies, because it will be local for them. It is not a FCRA for them. The other common issue that is going on right now, end of March, is refunding advances from FC account, bank account, deposit maturity and receiving back, and sale of assets and sale considerations. All the three are creating a lot of nuisance, lot of problems, because banks are not accepting. Banks are saying, sir, these are not FC money, we cannot accept it, and we will be hauled up by the RBI. Therefore, the clarity is, if the NPO can confirm that this advance is from a travel advance given to the staff, or a program advance given to a program head, program person, and they, of course, bank is asking for a confirmation or a certification by our member. If we do it, they credit it back. They credit it back. I am seeing just now that is happening. Last week, this week, it is happening. Similarly, certain deposits. I'm not talking purely only about bank deposit, FD, or long-term or short-term term deposit. I'm talking about other deposits, say telephone deposit or internet deposit, and when they are refunding, same issues are going on. And same thing is happening when the assets of FCRA are sold. If a vehicle, car, four-wheeler or two-wheeler, sometimes a land or a building, when these are sold, again the same issues are surfacing. What are the issues surfacing? Whether these are whether they can be credited back to the FCRA bank account. Another question that is coming up is whether these should be credited only in the Delhi bank account, the designated bank account, or the other FCRA account, or the utilization account. The answer is there in the portal itself, that it can be deposited in any of these three accounts or any of the two accounts if the utilization is not there. Section 17 of the FCRA is the relevant section which speaks about these three accounts. That is the mandatory account, that is the other FCRA account, and that is the utilization account. Now, yet another aspect I think I have already mentioned before, but by way of abundant caution, suspension, cancellation, denial of renewal, and entry in the seized list, presence in the seized list means no remittance can be received. Not only no remittance can be received, no utilization can take place. Of course, coming to suspension, if we apply to the FCRA for permission, up to 25% of the available money can be approved by Ministry of Home Affairs, FCRA division, for expenditure during the suspension period. And you may be aware that the suspension period originally was 180 days. Now it is doubled by the Amendment Act September 2020. So here also a lot of mistakes are taking place. Bank will know, bank gets the confirmation, communication from the Home Ministry, but without applying that such a communication, they simply keep crediting the FCRA bank account of these NPOs who are suspended, who are cancelled, who are seized list, and put the NPO into more trouble than they are already in at this point of time. I think I can go on and on. It's nearly, I think, about 50 plus minutes, 50 minutes. So I would like to leave FCRA here and request you to bring up if any special issues are there. I will definitely try to cover them in the question answer. And with your permission, I would like to move over to income tax. I just would like to know, am I still audible, clear?
You're audible and visible, sir.
Okay. May I proceed?
So, yes, sir. If you want, we can take up the question also. We have some 4 to 5 questions that came up actually. So we'll take it up at the end as we discussed, sir.
Okay.
Maybe once we complete presentation.
I think that will be better. That will be better if you don't mind. Is that all right? So that we can preserve the time and we can make sure that we cover all of them. Okay.
Yes, sir. Yes, sir. Yes.
Thank you. So I move on to the income tax. Again, here, so many things are happening. Those of you who are dealing, I'm sure you will say there is a fourth, there is a fifth, there is a sixth. But I would like to focus on three aspects under the income tax for NPOs. First one, the Finance Act 2020, the requirement of renewals and recognitions. Second is Finance Bill, and now I should correct this as Act, because since I prepared already last night, yesterday, it has become an Act. So sorry for this wrong mention there. It is Finance Act 2022. Amendments proposed for NPOs. No more amendment proposed. They are all amendments now. And then other issues for NPOs under the Income Tax Act. As you can make out, I am following same methodology like FCRA. Major issues, three of them: 2020 Act amendments and consequences, 22 Finance Act and consequences, and other issues. And first and second are clear because they are coming out of the law. And the third is, just some issues I'm picking up of what is going on through my regular relationship with our members, ongoing, continued, seamless relationship with the members and NPOs. I'm picking up a few of them, which I consider are very, very, common. But if there are other issues, we can discuss them. One thing you can notice, just like in FCRA, there was FCRA 2020 amendment, and again, FCRA renewals have come subsequently. Similarly, here there is a Finance Act 2020 where the renewals became mandatory. The renewal of 12A, 80G, and 3512 or 3513, etc. And then Finance Act 2022 has brought some very interesting kind of amendments. And therefore, I would like to first take up the Finance Act 2020, the renewals and the recognitions, very short time on that. Then I would like to spend little more time on the Finance Act 2022. Finance Act 2020, as you are well aware, we came to the 12 capital A, capital B regime. This is a new regime. In this, the renewals and recognitions, renewals for 12A or 12AA as the case may be, and then the recognition of 80G, they all became mandatory. As you are well aware, we have had special sessions. Last year, we had special session with SIRC, with also many branches of SIRC. And I must really admire the membership of our institute. Took a lot of energy, lot of time, lot of trouble to understand the requirements of this renewal, and they in fact applied, made so many applications, and also interestingly they have all been quick in the disposal. Many applications were disposed of sometimes in a day, a week. I have observed myself, just opposite to the Fcra renewal. They are very few comparing with the income tax renewal. Income tax renewal, even today, we do not know how many thousands or lakhs or millions. We don't know. But in Fcra, we know hardly less than 13,000, and of which hardly 2,500 or so are disposed of, and still many thousands are not done. But income tax, they are going so fast. What I would like to say that in the renewals also still there are some issues going on. And similarly, the 3512 and 3, you are familiar with this, the research application approval of section 3512, 3513, 3512 for scientific and 3513 for social or statistical. Now, one good news is on the 16th of this month, March has given a lot of revelations to the NPOs. 16th of this month, there is a circular of the CBDT, which is enabling the NPOs to file the application for approval of 3512 and 3513 in the physical form to the authorities. And if they have had difficulty in filing the electronic forms, they should now file the physical forms. So this is a good news. So those of them who could not file the electronic now can file the physical form for the renewal of the 35123 or all first fresh application of approval of 3512 and 3513. And then resulting issues arising out of the 12AB regime. I would like to take each one of this. First one, the very little, and third one a little more. Finance, yeah. In the first one, renewals and recognitions, I would like to say that many have applied with tremendous difficulty and got the approval. When I say tremendous difficulty, I cannot possibly explain in this session fully. There are members whom I admired a lot. They never had the trust deed. They never had ever any trust, something called trust deed. They never had any document, but the entity was going on. The activity was going on. Since when it was going on? Some were going on for 10 years, some were going on for 100 years. Believe me, some were going on for centuries. And our members went all the way to collect the available evidence of the existence of this entity or this institution or this temple or this church or this organization, and they built it up in a very good way, legal way. And then they went for a PAN, and they got the PAN as trust. Believe me, as a trust. Some trusts are not able to get a PAN as a trust with a T, fourth letter. even with the trust deed. But some of our members managed to get the PAN as a trust with these kind of entities. I have specific members in mind when I speak about it. I would like to really admire and congratulate them. They were such an inspiration to other people, and I used to quote them when others used to give problems. Sir, trust deed is not there, PAN is not there, or T is not there, or this is not there, or that is not there. I used to quote them that how they went about. However, I am sorry to say, even as of today, there are a number of NPOs who have not applied for the renewal in form number 10A as required under the new provisions of the section 12 capital A capital B. Therefore, high time, because 31st March next week, middle of next week, is the last date for the filing of the renewal application under section 12AB for new 12A fresh registration. Same thing is applicable also for recognitions. Absolutely. I do not want to repeat. Exactly the same thing is applicable for recognitions. However, I would like to say some have never had recognition under ATG. Now they applied. Of course, they were given not the 5-year renewal, but they are given the 3-year provisional. Quite fine. Then they can go for 5-year renewal later. But interestingly, or not so interestingly, some NPOs got ATG, though they are not entitled. For example, there are some religious NPOs. Religious, they've got ATG. You may ask me how they got ATG. Unless someone has applied, they cannot be granted ATG. Somebody has applied and they were granted ATG. So some of the members asked me what we shall do. I have been suggesting surrender it. See, sometimes it is not we are the only person applying. We have been advising, and the organization have their own some advisor or some staff there, and in the enthusiasm together with the 12A, they also apply for the ATG. So once as professionals we come to know about it, it is important for us to take a clear stand that this entity is not entitled for the ATG, and therefore it should be surrendered. And also we should strictly advise them not to receive any money through this ATG, because it will be a violation. This is nothing normal, nothing abnormal. For example, in Fcra, there are prohibited categories such as newspaper organizations. They have also been granted Fcra registration. It is a total violation, but it has happened. So my perspective here is not to worry about what has happened, to worry about how to remedy it, rectify it, so that the NPO does not get into serious problems. Now, another thing that has happened, it is not out of the way to say here, some of the renewals were made, or a few people made renewal application in the old 10A form, in the old portal also. How did it happen? Because Finance Act 2020 came in February 2020, and it became a law in March 2020. And from 1st April 2020, it is a law. And the last date was 30th June, if you remember, for applying for fresh registration. And it was extended to October, then it was extended to March 2021. In the interim period, some of our members, out of help or out of enthusiasm, out of eagerness to support the NPO, they applied in the old Form 10A. I'm sure you understand what I'm saying. Because by the time the new Form 10A, common Form 10A, for making the fresh registration for 12A, ATG 35123 did not come. So what has happened? Few cases the rejection took place for them because they did not follow up, or they did not answer, or the income tax the commissioner also felt why this is there, already they have 12A rejection. Some cases, fortunately, they withdrew the application. The members, our members came to know about it, or they understood that it is not necessary, we should wait, and they withdrew it. And the commissioner also accepted the withdrawal in writing. But what has happened since then? This information was captured by the faceless assessment, the national e-assessment process. and SCN, show cause notice, saying that your 12A is withdrawn. Therefore, you will have to pay tax as if not registered under the section 12A. Friends, we are all aware that 12A cannot be withdrawn by the assessee unilaterally. 12A can only be cancelled following the due process by the Commissioner of Income Tax. You may be aware that in the case of Tata, if you go to the Google, you will find they wanted to withdraw the registration to avoid whatever, potential risk. But the department took a stand. They cannot withdraw. RCC cannot withdraw. It's only the department who can cancel the 12A. But here is a case where the application made out of eagerness, in goodwill, and once the members come to know that it is not really right application, we have to wait for the new form and withdrew and explained to the commissioner. Commissioner also granted the withdrawal or allowed the withdrawal in writing, and the original 12A is intact, absolutely untouched. Unfortunately, the faceless assessment wants to tax it as a AOP with not having 12A. Just for your information, if you come across any such case, if you come across any other yourself, you may please take it up, saying that original 12A is intact until 31st March 2021. It's only from 1st April 2021 the new 12A under the new regime of section 12 capital A capital B becomes applicable, and there was not a single moment where the NPO did not have registration. It is a seamless registration right from the original, whichever 1973 it started. From then onwards, it could have been 1983, 1990, or whenever, and up till 31st March 2021, unless the cancellation has taken place earlier. There is no such cancellation in the case I am referring. There was only a withdrawal, and that too because of the application made. Now, sorry, I took a little bit of time because unfortunately the assessees and also ourselves are becoming victims sometimes, victims because of this kind of situation. And of course, I would like to say one more thing here. The department also is having challenges. For example, in the past, the orders were passed by the Exemption Directorate, Commissioner of Exemption, and the officers there. They are having a knowledge bank on exemptions, and exemption knowledge is completely different from the business assessment. Every definition is different. Income definition there is different, here is different. Deduction methodology here is different, there is different. For example, capital expenditure is fully allowed here, and there it is only the depreciation allowed. So many differences, as you are well aware. Unfortunately, today in the faceless assessment, there is no separate set of people to assess non-profits, or there is no separate set of people to assess salary cases or business cases. Everybody is given every case, I am told, and therefore lot of problems are going on, and unfortunately the NPOs are kind of becoming the victims, and I think we need to be cautious and careful in this matter. Having said this, I would like to go quickly to Finance Act 2022 and the implications for the NPOs. I would like to give credit here to the department, the DTRTI. As a resource person myself to the DTRTI, I interact with them, they interact with me, and they already had a course, and they already had a session on the implications of the Finance Bill 2022. And one Mr. Benziger, who have shared this, gave me permission to use it. So instead of me preparing separately, I'm using this slides, and they are clear. They are clear about the implications. Rationalization of the provision of charitable trust and institutions in the Finance Bill 2022. Now it is an act. Finance Act 2022. There are 2 new sections, 2 new subsections, 12 and 84 amendments, 18 new explanation, 10 new provisos, and 9 provisos substituted. We are hearing about 2 regimes, that is 1023 regime and 12A regime. And there is a third one here. They are speaking about third regime, that is 1023C, but not covered under the approval category. These, as you are aware, substantially financed by the government, medical, educational, and also below 1 crore, medical, educational, the third regime. See, this classification is very meaningful, very important. When you go to some other slides from now, you will see the importance of the third regime. Now, what is the intention of the government for bringing amendments in this Finance Act 2022 for NPOs? Three. One is ensuring their effective monitoring and implementation. Two, bringing consistency in the provisions of the two exemptions. That is, exemption, two exemptions when we say the 1023C exemption and the 12A exemption. And then the third is providing clarity on taxation in certain circumstances. These are three things I believe they have brought lot of clarity to some of the very ambiguous, vague situations existing for the last few decades. Look at one by one. First one, ensuring effective monitoring and implementation. Number one, ensuring effective monitoring and implementation, books of accounts to be maintained by the trusts or institutions under both the regimes. Many never bothered about any provision regarding books of accounts for NPOs. Why? Because 12AB, small b, already required audit of accounts when it is exceeding the basic exemption limit. Therefore, how can we have audit of accounts unless the books of accounts are prepared? Now, the clear provision has come both for the regime 1023 regime as well as for the 12A regime. Books maintenance is mandatory, just like in the case of 44AB. This is number one. Number two, penalty for passing on unreasonable benefits to trustees or specified persons. Another nightmarish provision is 13(1)(c) and 13(1)(d) regarding investment, and then the connected provisions there. And we used to wonder what will be the implication. Often we used to worry about cancellation of the registration. Fortunately, now there is more clarity. What is the clarity? The new section 271 double capital A capital E without prejudice to any other provisions of the chapter discourage such misuse of the funds. For the first time violation 100% and second time violation 200% penalty. These amendments are fortunately 1 year, 1st April 2023. So you can see now one what can I say, blessing in disguise is that this may not directly, this should not directly result in the cancellation of 12A, because 13(1)(c) violation, just like 13(1)(d) violation, is also one of the reasons for cancellation of 12A. Now, fortunately, that will not happen because the penalty will be paid. Now, again, who will pay the penalty? It will be the assessee trust. Assessee trust. Why assessee trust is paying the penalty? Because the mistake is made by the assessee trust. Why not the penalty by the recipient? The recipient says he is already paying the tax on this. When he gets any benefit, he is paying the tax on that. So the tax, now this penalty is on the entity. Of course, someone can say question when that entity has to pay this penalty, the poor beneficiaries are suffering. The only consolation is, instead of the entity losing its 12A fully, at least the penalty is paid and still the entity can continue its work. Now, third, reference to the principal chief commissioner or chief commissioner for cancellation of registration or approval. The amendment, section 12AB, subsection 4, and the 15th proviso to section 1023C, with the cascading amendment in the first, second, and third proviso to section 143.3. 143.3 is the assessment process, and clause 3 of explanation 1 of section 153 is the time limit section. The cascading amendments will be there, but more important is the grounds during the previous year for reference to cancellation. Occurrence of the violations noticed by the PCIT and CIT, reference by the assessing officer to PCIT, CIT, and the second proviso to section 143.3. 143.3 is the assessment process, as you are well aware, and second proviso that talks about the scrutiny for the assessment. And that time, if they notice, then the reference will be made to the commissioner. And cases selected under the risk management strategy. The department is following a risk management strategy. Under that, if the case is selected, then it will also be referred. Now, further, what is the procedure now? The procedure is call for documents, information, or make inquiry to satisfy himself about the occurrence or the otherwise of the specified violation, afford reasonable opportunity of being heard, pass an order cancelling the registration or refusing to cancel the registration. Forward a copy of the order to the assessing officer, the trust, and the institution. And time limit is 6 months from the end of the quarter in which the first notice is issued by the PCIT and the CIT. The PCIT and the CIT issue the notice based on the reference by the assessing officer. And assessing officer refers to the PCIT, CIT based on the grounds, circumstances that we saw above. Okay. Reference to PCIT, CIT for cancellation of registration or the approval. Definition of specified violation. What is the definition of specified violation? Income applied other than for the objects. Both in the first regime and the second regime, it is applicable. Business income not incidental. No separate books of accounts maintained for the incidental business activity. Even though the business is incidental, no separate account is maintained, then this is also a cause. Definition of specified violation both for the first regime and the second regime. And income applied for private religious purpose does not arise in the case of first regime, because first regime is more for the education or medical. Second regime, it is possible a public religious trust if the income is applied for private religious purpose. For example, instead of public worship, it's only a family deity or so, then this will become a specified violation for the 12A regime under the 12AB 4. And then income applied for the benefit of any particular religious community or cost applicable only to trust created after the enactment of this Act 1961. That is again a specified violation for second regime, 12AB regime, and not for this category 1023C. Any activity not genuine or not as per the conditions of registration. What do you mean not genuine? If the activity is, for example, nothing to do with the objectives of the trust, it is simply I came across a case which I asked for permission to quote. Yeah, agricultural university is selling sheep. Now, whether that selling of sheep is a activity for agricultural university is a question. It is purely a commercial. If it is a incidental, or if it is a related or integral part of the main activity, then it's a different matter. But if it is not proved to be genuine, then that is a ground. Another is not as per the conditions. Very simple condition is if it is for charitable and if it is applied for religious purpose or vice versa, it will be not as per the conditions. And non-compliance of any other law. This is another, as you know, a reason provision which is very serious. For example, the NPO can be very good in the income tax compliance or FCRA compliance, but if the NPO has not complied with some other law, for example, school is going on in an unapproved building, whether it will be a violation of any other law? Yes, it is a violation of any other law, because the building is for running the school, and running the school is the main activity. But one important point is, if it is disputed, it cannot be taken as a ground until it attains the finality. If the finality is that there is a violation, then yes, it will become a specified violation. But if the finality it is in favor of the institution and it is not against the institution, then it will not be a specified violation. Now we go to another aspect, bringing consistency in the provisions of the two regimes. Over the last few decades means almost from the beginning of 1961 law, this has been going on. The inconsistency, the two separate regimes in two separate directions, and the going back and forth, and the confusion resulting from there were going on. So there has been tremendous effort now to bring consistency in the two regimes. That is accumulation provision. For example, unutilized accumulation income and not utilized for the purpose for it so accumulated in the 5th year. You may be aware, or we are all aware, that there are two types of accumulations. One is for 1 year, other is for 5 years. This 5 year was in the past for 10 years, but it is restricted to 5 years quite long time back. Now there was a provision until this amendment, 5th year or the next year. There was a wording there. Therefore, the officers also were under confusion. Should they tax in the 5th year when it is unspent, or when should they go to 6th year and then see whether it is already spent? So some were allowing up to the 6th year, and if it was utilized, they were not taxing. And some were not allowing to 6th year, only 5th year. 5th year, if it was not utilized, accumulated and not utilized, they tax it. Now that is set right now. That is now only 5th year. It cannot go to the 6th year at all. Next one, statement of purposes and period of accumulation, maximum 5 years in the prescribed form, manner with which due under section 139(1). This is also become common for both the regime. Money accumulated to be invested as per section 11(5) has become common for both. Change of purpose can be sought from the AO. Amendment proposed in section 11 subsection 3 and to insert explanation 3, 4, 5 to the third proviso to section 1023C with effect from 1st April 2023. Now another one, payment to specified persons. Inserted 21st proviso to section 1023C. There is a story of this proviso. In section 11, we know that section 11 is a long section and it has got many subsections, section 11.1 to 11.2, 11.10. Now, whereas in 1023C, there was no 1023C itself is a subclause of subsection 1023C of section 10. But the provisos were limited in the past. They went on adding the proviso. So now the 21st proviso to section 1023C says subsection 246 of section 13 shall apply to the trust or the institution under the first regime. Any unreasonable benefit extended directly or indirectly to any specified person as per section 13.3, the related persons. The value of such benefit shall be deemed to be the income of the trust during the previous year in which it is so applied. Taxable at special rate under section 115 B double capital B I capital I. This is a new section that has come in the Finance Act 2022. So in other words, 21st proviso and subsection 246 of 13, they both make this common for both, that if there is a violation here, then it will be taxed under the special rate. Now we go to the accreted income tax. You are familiar that section 115 TD, TE, TF, they speak of the accreted income tax for the NPOs. Chapter 12, capital E, capital B, introduced as far back in the Finance Act 2016, provides for taxation of accreted income of the trust in certain cases. Upon winding up a dissolution, failure to transfer all assets to any other specified person within a year, within 12 months. This is one scenario, one situation. Another, merger with any other entity not having similar objects and not registered under 12AB or approved under 1023C, neither in the first regime nor in the second regime. Third situation or scenario, conversion of a non-profit into a commercial, conversion into a non-charitable, a non-profit into a non-profit, that is non-charitable. In these three scenarios, the now it has become common for both. Intends to impose levy in the nature of exit tax on aggregate of fair market value of the assets reduced by the liability. Now, the fourth one is filing of return of income within the due date required to claim exemption under section 1023C. Gone are the days when some of us were all, apprentices, and then over the last 3 decades, 4 decades, we used to go on applying for extension of filing, extension of time for filing the return, extension of time for filing the return. So many extensions we used to make ourselves, claim ourselves. Everything is gone. Now, 12 capital A, 1 small b small a says return of income has to be furnished under section 139 4 capital A within the time allowed therein to claim the exemption under section 11 or 12. No extension allowed. If the return is not filed within the time allowed, for example, this year, the audit report was February 15th and the ITR 7 was March 15th. And the last year it was before the ITR itself was February 15th, as you know. So similarly, the 20th proviso to section 1023C is inserted to require the trust to file the return of income as per the provisions of section 139 4C. 139 4C is for this regime, 1023 regime, and 139 4A capital A is for the other regime, that is for the 12A regime, the time limit for furnishing these returns. Clearly, if the returns are not filed within this time limit, they will lose the exemption. Now we go to the last part, providing clarity on taxation in certain circumstances. Welcome provision. Though this is talking about taxing, it is a welcome provision because we get clarity here instead of ambiguity. Instead of vagueness, we get a lot of clarity here. So allowing certain expenditure in case of denial of exemption, certain provisions which mandate denial of exemption, commercial receipts exceed in excess of 20% annual receipts in violation of section 215. You are aware of the proviso to section 215, which came in the Finance Act 2008, which originally they said 10 lakhs, then they increased it to 25 lakhs, and then they made it 20%. It should not exceed 20% of the annual receipts. So if there is a violation, what was happening? I'm sure some of you will recollect the commissioner went into serious action of cancelling the 12A. We have still some cases not fully settled, unfortunately. Now they don't have to do that. They don't have to do that. They only have to pay the tax. Second, not getting the books of accounts audited, violation of audit, not filing the return of income within the time limit. Presently, no clarity on computation of taxable income. Proposed to insert 10 in section 13, subsection 10 in section 13, expenditure to be allowed except in capital in nature. But for the capital, depreciation will be allowed. You can see the third bullet. Such expenditure is not from the corpus or the loan or the borrowing. The expenditure is not from the corpus or the loan or the borrowing. It has to be from the income. And of course, as I said, depreciation in respect of asset, acquisition of which has not been claimed as application in any previous year, of course, will be allowed as expenditure. Such expenditure is not in the form of a donation. A donation to another entity or anybody will not be considered an expenditure for the purpose of computation here. Now, propose to insert an explanation to section 1310 while allowing expenditure the provisions of 40A 1A, the TDS, 40 capital A 3 and 3 capital A. These are the cash expenditure exceeding 10,000. They will all apply. They are all already applicable even otherwise, during the normal assessment process. Proposed to insert subsection 11 to section 13 while computing income under section 1310. No deduction in respect of any expenditure or allowance or set off of any loss shall be allowed to the assessee under any other provisions of the Act. Proposed to insert 22nd and 23rd proviso to section 1023C and an explanation after section 10 22nd proviso similar to the provisions contained in section 13, section 1311 while dealing with the violation of 10th, 18th, 20th and the proviso to section 1023C. In other words, these are, though they sound negative, they are in a way positive because we don't have vagueness or ambiguity. Now, when there is a violation, there is a methodology for computation and then resultant payment of tax. Now, taxation of certain income under both the regimes, that's a 12-year regime and 1023C regime, at special rates. Denial of exemption for small amount of violation applied in violation of 13.1c. 13.1c is for related persons, and 13.1d, that is for investment, or 21st or 3rd proviso to section 1023C creates difficulties to trust under both the regimes. Investment in modes other than specified in 11.5 in violation of 13.1d or explanation of 4 or 3 to proviso to 13c. Unutilized sum of accumulated income within 5 years. There is ambiguity about the manner of taxation of such violations. Still, there is that problem is there. Now, proposed to insert new section 115 BBI to tax the above violations, the above small violations. The income tax payable shall be the aggregate of the amount of income tax calculated at the rate of 30% on the aggregate specified income. The amount of taxable chargeable on the total income reduced by aggregate of specified income. No deduction in respect of any expenditure or allowance or set off any loss shall be allowed under any provisions of the Act. Now, what are those specified income? I spoke about 115 capital double capital B and capital I earlier. New section, income accumulated in excess of 15% where accumulation is not allowed under any specific provisions of the Act. Income applied for the purpose other than the objects. Accumulated income not utilized for the purpose for which so accumulated. Accumulated income invested in modes other than specified in section 11.5. Amount applied outside India under section 11.1c without approval of the CBDT. Each one, has a big story behind. For example, if you take accumulated income in excess of 15% where accumulation is not allowed under any specific provisions of the Act. There are so many cases that have happened in the past. Similarly, accumulated other than the purpose also has happened. Accumulated not utilized for the purpose also has happened. Sometimes deliberate, many times not deliberate, but by kind of negligence. And then the accumulated income invested in modes. So many stories are there. What are they? There are a number of cases where out of 100 crore portfolio of a large hospital, just 10 lakhs or sometimes 1 lakh is the violative income. But entire exemption was lost. Fortunately, they went up to courts and the courts have held not the entire income, but only that portion is taxable. That portion of the violated investments income alone is taxable. If there is no income at all from the violated investment, then what is to be taxable? Notional income has to be taxed. Similarly, applied outside India has also a lot of stories. Of course, on the accumulated income, you may be familiar with the Father Muller's Hospital in the Karnataka High Court and Women's Forum in the Madras High Court. There are quite a few other cases, opposite, favorable and not favorable. Now they are all become not relevant because now they will all become under the specified income and subject to taxation. Similarly, outside India has number of situations. For example, in Nepal, when the earthquake happened, the government of India gave a general order that Indian NPOs can support the Nepal earthquake rehabilitation program, relief and rehabilitation program. There were a few instances in the past. There are also instances when Indian entities want to set up chair on, for example, a particular language chair in one of the universities abroad, and they also gave permission. And right now there is a lot of discussions going on about whether Ukraine war, whether support can be given by the NPOs, So there is such a lot happening on the 11.1c also. But the point here is, if they are done without the approval, then they become a specified income, and then they will be taxable. Finally, voluntary contributions for renovation and repair of religious places notified under 80G2B. This is retrospective, not from the enactment of the law, from 1st April 2021. Any sums paid as donations for the renovation or repair of any such temple, mosque, gurdwara, church, or other place notified by the central government, etc., such donation may be treated as corpus subject to the conditions, must apply only for specific purpose, must not make donation to any person, maintain separately identifiable. Account should be maintained in such a way they are identifiable separately, and of course investments has to be as per section 11.5, and any explanation 3A and 3B to section 11.1, and explanation 1 capital A, 1 capital B to third proviso to section 1023C is inserted. If violated, such sum shall be deemed to be the income of the trust. As you are all aware, normally religious bodies are not given ATG recognition in this country. But these kind of repairs and renovation of religious place of importance, they are given under section separate clear provision of ATG 2B. And now the provision is saying that they can be considered as a corpus. In other words, they will not be subject to all this 85% application and then accumulation. Nothing. They will be considered as a corpus donation, which is I'm sure, welcome amendment. Clarifying that the application will be allowed only when it is actually paid. This is something very important. Any sum payable shall be considered as application of income only in the previous year in which such sum is actually paid, irrespective of the previous year in which liability to pay occurred, as per method of accounting regularly employed. This is a very clear provision. Something like the 43 capital B, and something like almost equaling to the FCRA provision. In FCRA also, utilization is considered only when it is actually utilized as per the receipts and payments account, not when it is outstanding, not when it is a provision. And similarly, this provision is coming here. And proposed insert explanation 3 to section 1023C and explanation to section 11. Proposed also to insert proviso to proposed explanation provide that where during the previous year any sum has been claimed to have been applied, such sum shall not be allowed as application in any subsequent year. This is by way of abundant caution. If it is already claimed to have been applied, it will not be allowed double application in the subsequent year. Now, is very important part. Good to know this. How is it they are consistent with each other, both the regime? Previously, in the 80s and late 70s and 80s, even up to 90s, we used to call this 1023 as a total exemption, meaning there was no requirement. I am still remembering there were two sections, 1022 and 1022 capital A. 1022 was for educational institutions and 1022 capital A was for medical institutions. Both of them had absolutely no requirement of maintenance of accounts. That is even up to last year. Only now it is becoming mandatory. No requirement for audit, no requirement for investment, no requirement for filing of the return, no requirement for anything. And year after year, starting from the late 90s, 1022 and 1022A went out of the statute, completely deleted, and then 1023C regime came in. 1023C regime came in with the first non-approval category, that is substantially financed by the government. And then below 1 crore category. Now it is 5 crores, as you are aware. Now above 1 crore at that time, and of course institutions of nationally important, both religious and charitable, they were all required to get the approval of the CBD at that time, and later on it became the PCIT or the CIT. Now from there, sea change has happened. We have traveled a long way. Today both are consistent with each other. I do not think there is any more it is any more relevant to call the 1023 as a total exemption. It is total. It is absolutely, totally, wholly equal to the 11, 12, 13 regime. Of course, small minor differences are still there. Perhaps I can mention that little later. But consistencies, number one, books of accounts are to be maintained as per the 10th proviso in 1023C, 12A, 1B in the other regime. Unreasonable benefits passing on to the related persons in 30 as per 13.3, 25th, 21st proviso will tax 100% penalty, 200% second time, and that is also there in 13.1C, investment of funds in 11.5 other than 11.5, third proviso explanation 4, and 13.1D of this other regime. Specified violation for cancellation of registration or approval, 15th proviso to explanation 2, and or the explanation 2 to the 15th proviso, and 12AB subsection 4, filing of form 10 for accumulation for 5 years, explanation 3 to third proviso, and section 11.2, and taxation of unutilized accumulated income to be taxed in the 5th year. Now it's clear, and both are there, as I already mentioned earlier. Change of purpose specified in form number 10, accumulated income not to be transferred to any other trust or institution. Also prohibition is common, both under 1023 regime in explanation 5 to third proviso, and section 11.3 of the act. Possibly one or two minor 1 year accumulation, both are there in both the regimes, but in 11 there is a requirement for 9A application, and 1023C there is no such requirement to upload a 9A application. Of course, that has also resulted in filing the return. For some people had a problem in filing the return for 1023C, because it said what about 9A return, 9A form for accumulation, application for accumulation, whereas that is not really required. Now, allowing certain expenditure in case of denial is common. Taxation of only the violated portion at MMR under the newly introduced 115 BBI is now common. Denial of exemption for non-filing of then of income as per 139 4A for 11 regime, 4C for 1023 regime is also common. Voluntary contribution for renovation and repair of religious places may be treated as corpus is come into the statute for both now at the same time. Application will be allowed on payment basis and not payable basis is now common for both. And exit tax on accreted income 115 TD, TE, TF applies to both the regimes on dissolution, merger or surrender or conversion. Now it's already 6:45. I am given exactly 6:45 as the time limit and 15 minutes. Would you mind I take another 2-3 minutes?
Yes, sir. Maybe, sir. We have another 15 or 20 questions compiled actually. So maybe after this we'll take it.
Oh, okay.
At least 15
I'll
questions.
quickly finish this then.
Yes, sir. Thank you.
I'll quickly finish this.
Okay,
When members are so busy with March ending, 15 questions is a big number.
Yes, sir.
So I will surely immediately finish it. Other issues for NPOs under the Income Tax Act. Faceless assessment process and the implications. The less I speak is better, given the time also. But I just would like to say tremendous difficulties have been created. While it is a tremendous facility, it's an excellent facility, no question, particularly in the pandemic times, it was such a great facility, but it has also created a lot of issues. I have mentioned to you about the withdrawal of the application made in eagerness for compliance, and then the department wanting to tax is just one of the hundreds of examples, hundreds of situations. I do not want to go into all of them, but I would like to say, let us let us exercise high alert. Let us exercise caution to see what is coming, particularly the time limit. The time limit for the uploading of the documents is very, very short, especially in the case of NPO, so difficult, so challenging to get all the information. And after getting all the information, to put them in the digital format is another challenge. And when you put all of them digitally, they don't tally, unfortunately. We have to do all over again. And finally, when in the last 10 minutes or 15 minutes, when we are about to upload, the portal gets closed automatically. So we need to exercise high caution. CSR under the Companies Act and availability of 12A. This has created another problem. I'm sure you are aware, some of you, that the CSR is a very high focus for NPOs, and Ministry of Corporate Affairs is increasing its vigilance on the CSR. CSR Form 1 came compulsory from 1st April 2021, and from 11th February 2022, CSR 2, the reporting format has become mandatory for the companies. Now, CSR 1 registration, when we want to do in the Ministry of Corporate Affairs portal, MCA portal, requires 12A as an important document. If 12A is not there, we cannot apply for CSR 1. I've been looking forward this anomaly to be corrected, but unfortunately, this is not happening. Now, some are having 1023C, they are entitled for 1023C, and they have applied for 1023C, and they have availed 1023C, but they also need CSR 1. Unfortunately, they are not able to register for CSR 1, because of the non-availability of the other regime option 12A. This is definitely an anomaly. How can it be? But of course, some are arguing to say that, sir, if it is 1023C, it's only restricted, it is only for medical purpose or educational purpose. Yes, I don't deny, but educational purpose is also allowed under 135, section 135 of the Companies Act 2013, and also education purposes in the Sustainable Development Goals, SDG, the successor of MDG. The Millennium Development Goals was the first, and the SDG is the second, universal, global. In the global, education is important priority, in fact the topmost priority. And what's wrong if 1023 institution wants to get CSR spend, and I will be eligible for CSR 1 registration? So this needs attention from the side of the government. But for the time being, if you ask me, you may have to switch back to 12A. But then again, switching back to 12A, unlike in the past, is not possible back and forth. You can only do one time. If you go to the memorandum to the finance bill, you will see that the government does not want us to go back and forth with the first regime and second regime. They want us to stick to one regime. And if you have gone to 1023C, now you can switch back to 12A, but you cannot again go back to 1023C. And another one, PAN usage by trustees of trust and societies. Havoc is happening. Disaster is happening. How is it? Because their trustees have given their personal PAN at some point of time for some transaction, or to some bank account of the trust transaction, or the school or the college. I'm not talking about deliberate cases. There may be here and there deliberate cases where the money was to go to the personal account. I don't deny there can be, but I'm talking about genuine cases, or cases which are out of lack of attention that has happened, and now they are taxed. The national e-assessment is taxing them for crores and crores in some cases, unfortunately. So this is another area, and there are several issues are surfacing in the compliance landscape of the NPOs in the country. There is we can go on and on, but I would like to humbly request you to understand me that I only try to highlight the latest developments or the current happenings, and also with the specific focus on the timeline, that is 31st of March, which is not far away, which is just a few days away. But as I said in the beginning, a stitch on time can avoid 9, but in this case, I said in the beginning, it will be not 9 but 90. I'm sure you may now be inclined to agree with me that if we make one stitch on time now, we will avoid numerous stitches later on in the new financial year 2022. So with this sharing of my experience, and also again excusing that I have only touched upon the what can I say, the front office developments. In the back office, so many things are happening, and I would now submit myself for listening to your own challenges, your own questions, and I shall try my best to exchange further thoughts with you. Thank you so much.
Sir, can we take up the questions, sir, now?
Sure, please go ahead.
Sir, I'll show my screen, sir. 1 minute. So is my screen Excel sheet visible, sir?
Not yet. Not yet. Should I do anything, Selva?
Sir, no, sir. It should be visible, sir. Are you able to?
Yeah. It has come. It has come. It has come.
Okay.
It has come.
Okay, sir.
Sure.
So first question is the first one. It came a big one. Next one, pick up a lot. Want us to read out, or else you can see it, sir, clearly?
Yeah. You can read out if you don't mind. That will give me few seconds to digest and answer. Go ahead.
Okay, sir. So actually, under the recent amendment, it is prohibited to transfer funds from one FCRA registered entity to another FCRA registered entity. There are two FC registered public charitable trust A and B. Debit notes are raised by A to B, and the same is settled by B, and vice versa. For example, A supplies staff to B, and for B's project, and A raises debit note of salary expenses of those staff to B, and the same is being given by B to A. And similarly, for other expenses, line rent, electricity also, whether this is permitted and fall within the ambit of transfer of fund under FCRA Act as per the recent amendment, whether the reimbursement of expenses between two FC registered entities fall within the ambit of transfer of funds under recent amendment in FCRA Act. Please, sir.
Okay. All right. Let me mention to you, I come across numerous cases of this type, particularly when they are all in a same group. When in a same group, when I say same group, there are organizations who belong to a particular group or a particular set of institutions. One has got FCRA, the other not. But in this case, we are talking about two registered, both are registered. Am I right? Am I understanding like that? There are two FC registered public charitable trusts. Both are registered, right? And therefore, the question arises whether these transactions will amount to prohibition under the new amendment of Section 7 of the FCRA 2020. Okay, the first one, debit notes raised by A to B and the same is settled by B. A supplies staff to B, therefore B's project and A raises a debit note. Now, this is one category. I fully understand. I sometimes call this, like in certain cases, secondment of staff. Government has a very established practice of seconding the staff from state to central to international, etc. So I call something like that in that category, whether this is permitted. Next is a reimbursement of expenses between two FCRA entities fall within the ambit transfer of funds under the recent. Let me tell you, both are in one sense, definitely in my opinion, cannot be considered as a transfer of donation, because both are in the nature of meeting the cost. It's an expenditure and not a transfer. Having said that, let me just put a caution to you that whether the FCRA people will agree for this explanation, this interpretation is a question. I would like to say that when this is not a deliberate kind of a strategy, but this is just a genuine method. For example, in a second case, live, I have examples where the electricity connection is only in the name of one entity, but the other entity is also using the office, and the first entity receives the bill from the electricity department, and passes on one portion of that bill, saying that this is your electricity. They even have a meter for that. Now, whether this reimbursement, whether this is can be considered as a donation or no, it cannot be, because it is meeting the cost. So I would say, if we are able to substantiate in this case, example I gave, that here is this case, electricity connection by them, and I am using the office. I can't afford a separate office, separate electricity, separate everything infrastructure. I am a smaller trust. It should be possible for us to convince. But I must tell you, in inspections by the Fcra, they have not been treating this positively. They have been treating this as a not a not a acceptable transaction.
Okay,
Would you please go next one, please?
Yeah, the next question is why MHA taking lot of time in renewing FCRA and extension again? Will MHA complete by June 2022? And when would be the next renewal?
I'm happy to see that I'm asked to share my thoughts. I'm happy to do it, because this question has to go to the concerned minister and then the concerned ministry. But I'm happy to share my thoughts. First of all, the first renewal is not this renewal. The first set of renewal is 2016. After the new law came into the statute, that is 2010 and 2011 rules, the first set of renewals took place after the first May 11, 12, 13, 14, 15, 16. Most renewals happened. Of course, some renewals went into problems, but not so many problems, so much problems. Whereas this renewal is completely different. This renewal is happening after the amendment of September 2020, where the law says that no renewal will happen without inquiry. And therefore, as you may be aware, those of you supporting NPOs, that inquiries have happened at how many levels? Number one, office level of the NPO. Number two, at the every trustee level, whether the trustee is in the village, nook and corner of the country. If there are 10 trustees and all over the various states, they appointed the inspectors in those places. No inspector came for all the trustees. No single inspector, multiple inspectors. And they inquired with these trustees multiple questions, inconvenient questions, to the extent some trustees even said, why I have to be a trustee? Why I have to be in this, etc. So after all that, I believe all those reports of the inspectors put together have not yet been all compiled, because there are some 13,000 plus entities. And in the NPOs, you are familiar, from one trustee, two trustee to 150 trustee NPOs are there. Several, large number of trustees. So it has been taking time. Of course, the NPOs are also under heavy stress, not able to give all the information quickly, because the kind of information they are asking are quite a lot, much more than the income tax, and also for sometimes several years. And also they are not able to immediately make the trustees available. Trustees also, some trustees are, as I was telling earlier, not in the country, and not outside the country, etc. These are the reasons that I am able to feel, and therefore they have only two choices: one, to finish all the audits, or they have to extend, because the ball is in their court. People have already made their applications in form number 3C. So I do not want to be pessimistic. But I was telling right in December, I was telling when in first extension took place to September, from May to June, I said nothing is going to happen by June. And June to September, I was saying the same thing in the sessions and with others. And December, I also said the same thing. 3 months, nothing came at that time. And now, as of March, now, as I was sharing in the beginning, very few registrations have happened. Yes, they have happened. And some rejections have happened. Still numerous, majority of them, no disposal. So I just wish that they all be disposed of by 30th June, but no guarantee that they can all be finished by 30th June. These are my thoughts. And then therefore, be prepared. Use the best use of this extension. Right now, the extension is available from day before yesterday. So make best use of the exemption. When I say make best use of the exemption, even those who were not expecting the exemption, accepting the order, they were prepared to survive in the next 3 months. How to survive they were planning, make some payments to vendors and make sure some facilities are available, the organization can continue during at least for another 2-3 months, something like that. So I think it is for the NPOs to be thinking and planning to survive and continue. May I go to the next one?
Yes, sir. The third question. A trust with the objective of providing housing to the underprivileged constructed a temporary building as an office in the work site with the donation received from abroad, received in
Okay.
FCRA account. Post completion of the housing project, can the trust continue to use the site office as a trust office for conducting activities for its other objectives?
Of course. There's no question at all. See the building, the housing underprivileged temporary building as an office for the work of the site, and there is no prohibition why they cannot use the work of the office of the work site for other objectives. I don't think there is any prohibition at all. They are most welcome to use it. Yeah, in case there is some objection from the donor, there can be a problem, but easily donors will understand. They will rather promote if you are able to use it, for other objectives. They should have no issues. And so long there is no objection from the donors, specific objection from the donors, I do not see any problem at all. Shall we go to the next one?
If a registered charitable society could not submit application for renewal of registration under Section 12AB of the Income Tax Act before 31st March 2022, and they submit application for fresh registration in April 2022, what are the consequences? Why they be entitled for exemption under Section 11 for the assessment year 2022-23?
Okay. My first hope is just like the FCRA extension already came day before yesterday, hope that the extension will come also for the 12AB. Because even as of today, there are so many NPOs, they have not applied for the registration, particularly the grassroots ones. They don't even know, they have not been able to do it for the lot of difficulties they are facing. Therefore, hope that will happen. But in case that doesn't happen, there is a risk of that this will be assessed as an AOP. Without registration, it will be assessed as an AOP. Again, unfortunately, there is no, we cannot avail of any, unlike in the past, we used to get retrospective. But one thing, you always remember, you have the 12A2, still available for you. What is that? For the next year, if you are able to get 12A, and in the previous year, if you don't have any violation, you are again entitled for the exemption. I'm sure you are aware of that. Although I am not recommending that you should wait for that. Hope it is clear.
Next question, sir. If we didn't get commitment letter or letter of intent for applying the prior registration under FCRA, also can we upload declaration by done in lieu of donor's commitment letter in such cases?
Not really. I mean, you can upload, but this is an important requirement. It's an important requirement under the FCRA to have the donor's commitment letter. There is a big long story. I don't want to go backward too much, but I would like to say FCRA has experienced hundreds of prior approvals given, prior permission given. No money came because there was no commitment from any donor to give prior permission. And that's why they brought in this requirement. This is a very important requirement. I do not recommend making the application without the commitment letter.
Trust plan letter is containing F firm, bank not opening account. How to proceed, sir?
Of course. You are asking a very interesting one, which has happened to quite a few. In the 90s, when the PAN came, nobody bothered. What is the letter there? But in the last 5 years, to my knowledge, or a little more, 6 years, my knowledge, this has surfaced. Not only you are asking about bank not opening the account, the income tax portal is not opening for them. And when it is opening for them, the form ITR 7 is not coming for them. Other forms are coming for them. So definitely no more it is advisable to retain the F. You will have to go for T. And if you ask the department, it is my experience, not once or twice or multiple times, you cannot simply change it from F to T. You will have to surrender F and get T. And of course, you know the consequences when you get this surrender, and when you go for the T, there are other consequences. During the year, I have a case where multiple TDS is done. A few crores of TDS is done, but they have to go for T, and therefore then they have to refile it in favor of the new PAN, migration, all of that. Now for bank not opening the account, actually bank should not worry about it, to tell you, but unfortunately these are all becoming such a sticky issue. But for other reasons also, I would recommend that you go for T. Definitely. Okay. Can we go to the next question?
Yes, sir. My question is, when the FCRA funding agency sanctioned the fund for administration of the NPO, only in such cases how to make the ratio of 80:20 of core and admin prescribed by the Act.
Right. Yes, if I'm a diabetic, but I like only sweets, nothing else I will eat, you know, something like that. No, unfortunately, I know there are specific cases. I'm aware that the agency is giving for admin, and they do not want to give for other things. I mean, they are giving for admin because that helps us to get local funds from the government and other agencies. There is a purpose in why they give for admin. I would have to advise that, you will have to restructure. You, if possible, what I have done in certain cases, explain to the agency, look, this is the situation of the law and I cannot change the law. Perhaps if you can make this for the program, I will designate local funds for admin and give you whole picture, how I am doing it. Now, I'm not manipulating, I'm not siphoning, but I am restructuring just for compliance under the compliance of the law. And you are perfectly within the law if you restructure, explaining to the agency that I use this for program and equal amount I use from my local funds for admin. Nobody can question you. Shall we go to the next question?
We are unable to file a CSR1 form. What is the remedy?
Now, you will have to kindly tell me what is the problem you are facing. I gave you one problem earlier, that is a non-availability of 12A. If you give me what is the problem, then I can try to explain. Oh, no? Can we go to the next question?
Yes, sir. Today I tried uploading form 10A for renewal of registration. The form was not uploaded with an error message. However, no error was described. It seems like a portal issue. What to do if the problem continues till 31st March?
Then this question will be absolutely aligning with the other question. No, up to 31st March we are not able to apply, so my answer is also same, but I won't like to restrict my answer to same answer here. Keep trying. For example, I must tell you, on the other side, even for the expired appeals, expired returns, it is going sometimes. I do not know if you have heard about it. Yes, it is going sometimes, you know. So whereas this is well within the time limit, you should get it through. Kindly see, try to explore what is the error. For example, if the error is because the verification is not going through. The verification is not going through because the PAN and Aadhaar is not linked in the case of the verifying person under section 140%. So if you are trying to zero down to the nature of the error, I think you can try. I know you are already saying no error was described, but something that you can keep attempting, and I wish you succeed before 31st March. Don't go to 31st at all. Try succeeding by 30th March at least. Can we go to the next question?
Yes, sir. An education trust running a school for SC/ST students is getting 20 lakhs grant from the President of India every year for past 3 years. 12 registration not obtained. Is the income or grant taxable? The utilization is only towards charitable activities.
Yeah. See, the students are a particular category, it's an education, but it is not running any educational institution. It is only a scholarship. Am I right? No? Students getting 20 lakh grant from for what? 20 lakhs utilization toward charitable activities. I'm not getting clear here whether it is for what purpose. If it is, for example, I'm just saying school, then you can try to bring it under the 1023 3A, 1023C 3A, etc. But I'm not getting clarity whether it is what kind of expense. If it's only a scholarship or so, or if it's only a hostel for the students or so, we cannot get exemption. We cannot. You have to go through the legal process, legal framework, that is either 12A or 1023C. Otherwise, you will be facing the problem, even though the grant is from the President of India or from any other authority or any other government agency. Can we go to the next question?
Does 13.3 prohibits payment of salary to full-time employed trustees?
Not at all, not at all, not at all. They are only talking about unreasonable, reasonable or unreasonable. There is no still definition about what is reasonable, what is not reasonable. For in some cases, 1 lakh is unreasonable. In some other cases, 1 crore is reasonable. 1 crore is reasonable. People have proved, if they were in the market, they will be having 1 crore salary. I have a case in example, where the trustees proved if we are outside in the market, we will get more than this. And they proved it and they were accepted. But there are cases where 1 lakh also the trustee was not able to prove it. No question at all. Full-time employed trustees are welcome. Only thing, by their qualification, by their experience, by their contribution to the trust, meaning the professional contribution to the trust, they have to prove that it is reasonable. Absolutely no question. Can we go to the next question?
Sir, is there any possibility to revive FCRA registration which was already cancelled?
Definitely. This is not end of the road at all. That's not at all end of the road. You can go for wait for 3 years, but that is a timeline involved. Other is going on appeal. You have also possibility of going on appeal. There are people who have gone on appeal, and some have won, some have not. And there are people who waited for 3 years and they have reapplied. You are free to do. This is not end of the road. Can we go to the next question?
Accumulation up to 31/3/2021 will lapse as per finance year 2021. What will be the effect of accumulated application up to 31/3/2021?
Here, since the new provision, what I explained to you, the Finance Act 22 will come into effect only next year. If the accumulation is expired in 2021, and if they can apply even before 2022, next few days, for example, you are still through, because as of now, 6 years is also possibility. Can we go to the next question?
Okay. What is the remedy?
Sorry, Siva, you can go ahead.
What is the remedy available when income applied towards capital expenditure is disallowed and demand notice is issued in the case of institution registered under section 12AA T5R?
Capital expenditure is a allowed application. Under section 11(1)(a), both capital expenditure and revenue expenditures are absolutely allowed as application. As you know, the form ITR 7 or ITR utility, they all have specific place there for revenue expenditure and capital expenditure. So if the capital expenditure is disallowed, you are free to go on appeal and argue that this is a genuine capital expenditure for carrying out the objectives of the trust. So the ball is in the court of the trust to prove that it is an application, it is a genuine expenditure. Otherwise, in law, you are allowed. Absolutely no question. Provided this is the first time. You cannot get the capital expenditure allowed more than once. If it is the first time, you are very much entitled to get the capital expenditure allowed as application of income.
The last question, sir. This is with regard to the first question that we take. Can we contend the expenditure precedes the reimbursement and hence it is not the transfer of donation? The first question.
Yes. I gave you a clear example. I'm not only mentioning the name of these bodies. I have more than one example where the two trusts are there. or multiple trusts are there with multiple FCRA numbers, and because of the law operation of the system, like I gave you the electricity as an example, no, the whole campus has got one electric connection, big connection. They have their own transformer, multi-crore invested transformer, and everything comes to one trust. And they give lighting facility, all the electrical facility to another trust, and the another trust gets an invoice, that so much is your a portion, and give it, and they pay for that. So I'm giving an example, and if they question me, this is a contribution or a donation, I have enough documents to prove that it is absolutely a genuine expenditure and not in the nature of a transfer at all.
The last one, sir.
Yeah.
Question about the grant from President of India. That question. The grant is towards running a school for SC/ST students. 10
Okay.
Section 23C not yet
Yeah,
applied.
then you please apply 1023C that is substantially financed by the government. If your total turnover say X amount, and this is more than 50%, for example 51%, you don't need 12A, you don't need 1023C approval. You are eligible for the substantially financed category. You will be exempt.
Those were the questions,
Okay.
sir. We have only one more question.
Right.
If time permits,
Okay.
we'll take up, sir.
Yeah, go ahead. Please go. I'm okay. I'm okay. Please go ahead. If our vice chairman says, if our vice chairman CA Panaraj says, if take it up, I'll take it up.
Yes, it is your choice, sir. I think.
I'm happy to take it up, CA Panaraj.
No problem.
Please
No problem, sir. Because if the members are benefited, we have no issues.
Yeah,
sir,
yeah.
this
The
question,
purpose
sir,
is to benefit the members, so I am happy to answer. Please go ahead.
This question, sir, please explain the difference between Form 10A versus 10AB, whether when Form 10AB needs to be filed.
Okay. See, 10A is the common form. In the long past, 10A was only for the 12A. And then 80G, it is 10G. Form 10G was for 80G. And then 3CF, etc. for the 3512, 3513, etc. Different forms for different registrations and different approvals. Now it is 10A is a common form both for 12A registration as well as for the 80G recognition, and even for the what is called 3512, 3513. Of course, now I told you the physical form 3CF, which has been already in existence, is allowed for the research approval. Coming to 10AB, that is for a different purpose. Number one, when you have first availed the provisional registration, for 3 years, and you will have to go for a more permanent. More permanent means the 5-year registration. Then you use the 10AB. Now, as you may be aware, that the provisional registration cases are required to apply for the permanent registration. When we say permanent, again for the 5-year, 6 months, within 6 months of the commencement of the activities. So if, for example, some new trust has applied in, let us say in June end, so July, August, September, October, November, December, over. So they should have applied within December in 10AB for the next 5 years. Similarly, another case, when you want to modify the objectives of the entity from, let us say, some are doing that, expanding from religious, they are making it religious and charitable. Some are doing vice versa. Charitable, they are making charitable and religious. There are so many modifications are taking place. When I say modification, it the objects, not in the trusteeship or the governance. So in those all cases, we have to go for 10AB. And for your information, 10AB has come into already in the statute. Come in the statute. I mean, it is opening for. If it is opening, now we can use it. And of course, there is 10BC, 10BD, 10BD. You are not asking, but just by way of information, that is like TDS. We have to now file 10BD in the portal for donations. So no more we need to give donation certificates and the assessee has to file that with his or her income tax return, nothing. Just like TDS and 26AS, we have to now use 10BD and donations will be uploaded in the portal by the institution from whom all they received with what PAN, and automatically the assessee will get the rebate. Okay, 10AC, you all know 10AC is the order form. When you apply in 10A, they issue the order in 10AC. I hope this is helpful. Anything more? Anything more?
Last question. Sir, in FCRA, can a service, the last question, 1 minute.
Yes, please.
In FCRA, can service contracts with GST and TDS be permitted between two FCRA institutions instead of the sub-grant?
No, I don't recommend it. It is risky. You would have heard right from the amendment of 2020 from September last week 2020. This will be considered as a sham transaction, and it is risky. I do not recommend it. While I recommended, or while I strongly agreed that payments in the nature of genuine expenditure cannot be equated with the donation, here I would humbly disagree. I have to say that this is not advisable. Okay, anything more?
The last one. So FCRA trust registration applications made on 22nd September 21. Still nothing is heard from them. Is there any time limit to MHA to grant registration?
Unfortunately not. Unfortunately, they are not following anything. You are on 22nd September. There are applications from July, August, and September. Now, I would like to know, if possible, has inspection taken place? Number one. Otherwise, if inspection has not taken place, I would like to know whether any query is pending in the website, because these are two possibilities, like I already was saying it before. In number of not number of cases, but quite a few cases, query was pending. People were not knowing it, and when they did not get any email. So when we went to the portal, we found pending, and also link was available. Therefore, we gave the link, we gave the reply, and the registration has come through. So I request you to kindly check. But if inspection has not happened, you cannot do much about it. You have to just wait for it. There are quite a few where inspection also has not happened so far. So this is a situation for you will not be alone. There are quite a few in this situation. Okay. Before I close, I would like to say three things. First of all, thank you so much for CA Panaraj, Vice Chairman, and team of your office bearers for giving me this opportunity. As always, I'm very, very happy to share whatever knowledge or experience. Ultimately, together with such eminent professional groups that we are, the benefit is going to the people. And in this country today, if not at this time, there is no better time to do good. In any case, in any way, anywhere, to anyone. And therefore, I'm grateful to you for giving me this opportunity. I'm also very grateful to Ms. Uma and Ms. Monica and Selva, as always, for all their wonderful support and facilitation. And also, I'm thankful to each of the members who have joined here. If some of them have joined here at this time when there are so many other things to do before the 31st March, for some of us it is not, but it is like ending of the world, so many things happening. If you have joined, that shows your passion, your commitment, and your interest to support these NPOs. In turn, the NPOs will render their service to the humanity. So congratulations to you, and wish you a very happy financial year ending. Thank you so much, and over to you, Vice Chairman. Thank you so much.
Sir, we are grateful to you, sir, not that you are expressing your gratefulness for giving the opportunity. It shows the involvement of the members. You see the number of queries that are shooted to you, and after speaking for 2 hours, you have taken so much of time and efforts to clarify the doubts of the members. If at all any queries are there, if you permit us, we will mail them to you, sir, if possible. You can, if your mail ID is available, because some might have missed it because of this new year, the financial year ending. Some might have might not have attended. So those questions we will receive and send them to you by mail, sir. So heads off to your efforts, sir. You are the real pillars of the institute, not our structures. Our physical structure can be done by anybody, but we are, as you rightly said, this is the time to serve, not only in terms of service, but also in terms of upgrading, upskilling ourselves, and show that we are the one. We are very vibrant and dynamic in learning also, with the things that are happening, like proposition of IIA and all. We should gear up ourselves and prove ourselves to the government also, union government also, that we are in no way behind in as partners in nation building. So I request the members to upskill themselves, and we are here to serve you. And the stalwarts like Kandasami sir are there to serve the fraternity as such. So together we can is our mantra. Definitely we will together grow faster with high quality performance in our professional duties. So I thank you very much from the bottom of my heart for your time and your concern about the institute, sir. And also on behalf of SIRC, I thank you very much, and I thank the organizers, that is SIRC office, and the chairman and secretary for choosing this topic also. And also, more than anything else, the members who have attended and made use of this webinar, the one and only type of webinar by Kandasami sir. Who else can solve our doubts, if not by Kandasami sir? That's my statement. And you are the real assets, invaluable assets for the institute, and we keep learning from your guidance and presentations in the future also, sir. So thank you very much to you and all the members who have been participating here. Thank you. Thank you, and all, and good night.
Thank you so much, and you have a wonderful year ahead, C.A. Panaraj, and your team of.
Thank you, sir. We seek,
have a wonderful year ahead.
We seek your support like this always, sir. Yes, sir. Yes. Thank you. Thank you, Selva.
Thank you.
Special thanks to you. Monica, thank you very much.
Yeah.
And also Uma in absence, yeah. And all the back office at SIRC. Thank you.